Well, welcome, everyone. I am Kathleen Graham, the Executive Director of the SEC Historical Society. Thank you all so much for being here for today's program that celebrates the SEC's Office of the General Counsel. Not only do we have our distinguished panelists here with us today, but we also have members of the SEC's General Counsel Office, and we have current and former SEC staff. And we want to thank you very much for your service and your dedication to protecting investors. Also in the audience, we have, with name tags, our board of advisors and our trustees, which are our board of directors. And they have a little blue ribbon on them. So please meet them during the reception. And I want to thank you for your leadership and your advice. Also in the audience, we have donors. We are a nonprofit 501c3 organization that relies on the generosity of many people, and many donors are here in this audience today, and I want to thank you for your support. We're also grateful to Wilmer Hale. This is a beautiful space, so thank you so much for hosting. And lastly, I've been working in philanthropy for 30 years, and rarely have I ever met someone as generous of their time and their treasure as the SEC Chair, Meredith Cross. We are so grateful for your leadership. And she's also, thank you. Yeah. And a super clap because she is also sponsoring our reception today. So thank you so much, Meredith. Please come up to the podium.
I can't believe how many people I've loved working with over the years are here today. It just really is, it's a special day. And so thank you, everybody. And I was not SEC Chair notwithstanding. No, it wasn't on my to-do list. Anyway, it's great to see everyone. So the panel is called The Evolution of the Office of General Counsel. This is important. It's going into our museum. So just to be clear, this is actually part of our history that we will treasure in the SEC Historical Society website museum. And it's awesome for that. I'm so excited to have the 7 former general counsels here. And so thank you for that. And thank you for coming. So in my day job, I'm a partner in the securities and transactional departments at Wilmer Hale's New York office. I have a deep appreciation for the SEC and its history, having spent many years working there. It's a very special place and really changed my life when I went there in 1990 and then went back in 2009. So it's an honor to be here with all of you and to celebrate the SEC's history. While I was there the last time in 2009, I worked on more than 60 Dodd-Frank and Jobs Act and other rulemakings. And I wrote a lot of them at my dining room table. I will tell you, you were never not working when you're in those jobs at that time period. I also testified in Congress 9 times, which we joke was like being shot 9 times, but survived. Today's panel honors the legacy of Society founder and the 26th chairman of the SEC, Harvey L. Pitt, who we lost. He was the youngest general counsel in the agency's history, having been appointed in 1975 at the age of 30. It's amazing. We also want to recognize SEC General Counsel Giovanni Prezioso, who passed away in 2023, way too young. And Harvey Goldschmidt, who's a major force in the securities bar that we're all proud to have known, who passed away in 2015. Thank you for joining us today. We are grateful to our distinguished panel. I'm also grateful to my partner, Phil McLucas, who is moderating these panels. He was the longest serving director of the Division of Enforcement, and I'm so proud he's my partner. So with that, I'll turn it over to Bill. Thank you.
Thanks, Meredith, and thanks, Kathleen and the Historical Society, and Liz Gray and Jim Barrett for organizing this and helping everybody put it together. As you all know, the General Counsel's office is actually older than some of the people in this panel. It goes back about 91 years, I think it was. The office existed when the commission was formed. And as you're going to hear, the office is responsible for advising the SEC on appeals, on legislation, on adjudication, and on general litigation, rulemaking, and on ethics. Now, one of the things that you will not see when you look at the official description of the functions and responsibilities of the General Counsel's office is that it is also responsible for keeping the Division of Enforcement in line and watching over what goes on, as they used to say when I was there, down there. Now, this presents me with a rather unique opportunity, at least with respect to Cy and Dick and Jim, because I get to ask them some questions and harass them the way they used to harass me when I was in the enforcement division. And I've rarely had that opportunity. So all those questions that we pre-scripted in advance, I threw them out. But let's begin. Dan, you were the general counsel under John Shad, beginning in 1981 through 1990. You joined the commission when Ray Garrett was the chairman. You served under Rod Hills and then under Harold Williams. Take us back to that period of time, beginning, I think, in 1974, and give us a sense of what the agency was like and what the office was like and what some of the challenges were that the office faced.
Yeah. Thanks, Bill. Let me just join in thanking the Historical Society for putting on this program on the General Counsel's office and honoring Harvey Goldschmidt, Giovanni Precioso, and particularly Harvey Pitt. In my case, if it weren't for Harvey Pitt's support and mentorship when I was a young lawyer at the SEC, I definitely wouldn't be sitting here as part of this distinguished group, and I miss him every day. I joined the SEC staff on September 1st, 1974, as a staff attorney in the General Counsel's office. On that day, there were, I believe, 35 positions in the General Counsel's office. I don't know the exact breakdown of attorneys, but I wouldn't think there were more than 20 attorneys in the office at the time. In those days, of course, every brief, every letter, every memo that came out of the office was either written out in longhand by an attorney or more likely dictated and then turned into a document by the clerical staff, what were in those days called secretaries. So they were extremely important and busy people as part of the staff. Maybe just as an aside, we have, I think, 7 former general counsels here today between the two panels. On the day, well, we certainly didn't know it at the time. On the day I started in 1974, there were 6 present, future, or former general counsels working at the commission. Larry Nierheim was the general counsel. Phil Loomis, who had been general counsel, was on the commission. Walter North, who had been general counsel, was a senior advisor in the general counsel's office. An up-and-coming young fellow named Harvey Pitt was Chairman Garrett's executive assistant. And another up-and-coming young fellow, Ralph Ferrara, was also on the staff. I don't recall if Ralph was in enforcement then or he'd moved to the chairman's office at that point, but he was certainly at the commission. And in terms of what the general counsel's office was like and what it did, it was predominantly an appellate litigation shop. I would say 80% or more of the office's work involved representing the commission in appeals from enforcement actions. And the reason I joined the office was because I wanted to do appellate litigation. There were, however, little pieces of things that became later important parts of the general counsel's office's work. For example, it defended the commission when it was sued, which wasn't very often. But shortly after I joined, we were sued by the Natural Resources Defense Council, which sought to compel the commission to adopt environmental disclosure rules under the National Environmental Policy Act. And So I spent a good deal of my time for probably my first 2 years in the office on that litigation. The NRDC was represented by yet another former general counsel, Roger Foster, who retired from the commission several years earlier. The office also did some legislative work, although my sense is that most of the important legislative work was done in the divisions or the chairman's office. In those days, a central issue was the consideration and then the passage of the Securities Act amendments of 1975, which created market competition and the national market system, codified the unfixing of commission rates. And I think most of that work had been done probably by Harvey in the chairman's office, along with the division of market regulation. There was also a very small function of reviewing what the other offices and divisions were doing and reviewing the calendar. I'll if you want to talk about that separately, I'll stop there. But it was a minor part of the office.
Yeah.
Before you became the GC under Harold Williams, to get back to the other thing I mentioned, counseling section was created in the General Counsel's office. Now, remember the 70s was the Sporkin era, off the books accounts, predecessor investigations to the FCPA, in connection with the money being delivered to the committee to reelect the president. And by 1975 or so, there was a lot of resistance to the program, but Harold Williams set up a group called the Counseling Section in the General Counsel's office. I don't know if you were involved or have much recollection, but that was ended up being a function that well served the commission. But it also generated a fair amount of tension, as you can imagine, from the perspective of those in the enforcement division. Having the lawyers review our recommendations was not well received. What do you remember about that and how it was managed throughout the commission?
Well, yeah, no, I think you set it up very well. The counseling group was created while Farr was general counsel. And as you say, I think it was based on discussions between Chairman Williams and Ralph Farr about the need for, let's say, a counterbalance to particularly the enforcement division. And in those days, the questionable payments program was very much in the news and probably been one of the commission's greatest successes. And Stan Sporkin was undoubtedly the most famous person at the SEC, certainly a national figure. And, without being critical of those things, I think Harold felt that it would be helpful to have, not a contrary policy view, but at least an assessment of the legal risks associated with particularly some of the things that enforcement was doing. There had been some cases that the commission had lost. Maybe Hockfelder would be one of them, and I guess there would be other examples. And so there was a thought that there should be more insight into what the legal risks were associated, again, particularly with enforcement cases. So the three groups in the office were created, which I guess survived to this day: counseling, appellate litigation, and general litigation. And the counseling group had assistant general counsel groups in it, one assigned to each division in the commission. And so those groups would review what their division was recommending to the commission. And then we'd have a meeting on Monday mornings where whoever had reviewed a particular item made a presentation. Anyone in the office who wanted to come could attend. The divisions, I think, pretty soon got the idea that it would be wise if they sent representatives also to hear what the general counsel's office had to say about their matters. And the general counsel just became kind of a participant, if not a central figure, in everything the commission was doing in a way that it hadn't been before. Now, I will say it kind of went to another level under John Shadd. One thing John loved was debate. He'd like to argue about everything, and he didn't mind being the devil's advocate for many things, but he also didn't mind having the general counsel's office be the devil's advocate. He told me, I guess the word would be instructed, that we should oppose everything another division recommended to the commission so that the commission would have the benefit of an adversary process in all its decision-making. I didn't take that 100% seriously because some things were a little hard to opposed. But I think in those years, we really tried to make a point of trying to give the other side, if there was one, of what another division was recommending. And in fairness, particularly the enforcement division.
Well, Dan's very sort of eloquently and diplomatically described this, and I think you're correct. As it evolved, I wouldn't say that there ended up being the equivalent of fistfights between groups, but there were occasions when it probably got pretty close. John had a law degree. He was an investment banker from England, but he was an investment banker. He was a deal guy, and I think over time, the perspective, while the idea of engaging us in combat over recommendations probably didn't come to fruition, it was actually a valuable exercise, I think, on both sides of the table.
Oh yeah, no, I think that's right. I think that's right. The downside of it, or maybe I shouldn't call it downside, but the other kind of side of the story is, to me, it marked a major cultural change at the commission. And my sense surviving in the sort of the earlier mid-70s was that going all the way back to the 30s, there was sort of a feeling at the commission that it's us against the world, and we're David, and there are a lot of Goliaths out there that have to be slain. And it was very important that everyone worked together. It was extremely rare, almost unheard of, to have a split vote at the commission. There was no Sunshine Act, so if there was any debate about anything, it was behind closed doors, and in public, it was all a unified front. The counseling group, and again, this was something that Harold Williams and John Shadd wanted, I think was beginning of a change in the culture where there was more explicit debate about what we ought to be doing and questioning of things the divisions were recommending. And then it also began to manifest itself with commissioners who were a little more skeptical about some things. And for example, a person I love tremendously and have a lot of respect for, Roberta Carmel, had written a book called Regulation by Prosecution, and she was certainly willing to debate with Stanley at that time about enforcement recommendations. So just the whole culture at the commission began, I'd say, to change in those years.
Yeah, and by the way, I invite any other of my colleagues up here to chime in. There's so many stories, particularly during that period with Roberta on the commission, Stanley being the director of enforcement, and arguments at the commission table, which, as I look back, were quite remarkable.
Didn't Shadd think that all the leaks were coming from the lawyers and not from the investment bankers? The bankers couldn't be the leaker. It had to be the lawyers.
Well,
John was an interesting guy. He'd come from the brokerage industry, the securities industry. He had tremendous respect for the industry and the people in it. On the other hand, I think he was horrified by insider trading. He just felt it was something that, what you would say, people like him or the people he knew wouldn't do. So he really didn't have, I wouldn't say, any problem with an aggressive insider trading enforcement program. But he was very sensitive to things like, well, one thing he hated was failure to supervise cases. Here's something where you're going to punish a firm or a person who didn't really commit a violation. And I bet he voted against every failure to supervise case we had.
Every supervised case. John had a view, having come from the industry and frankly probably been a stand-up guy throughout his tenure, when the M&A period generated all these extraordinary revelations of fraud. Maurice Siegel taking briefcases full of cash in Lower Manhattan at night. He couldn't believe it. And I know for a fact the Dennis Levine case, which broke it all, Gary had to spend time in his office saying, we have his photo at Bank Blue. Taking the money out. We didn't make it up. Which is why ultimately John and then created an endowed chair at Harvard, $50 million to study that thing, because he was appalled at what had happened, at what he regarded as his industry.
Yeah, no, I think that's right. And as I said, I think he just had trouble accepting that people that he knew in the industry or people like him in the industry would engage in that kind of behavior.
So, Jim, let me turn to you for a minute, because you were the next general counsel under Richard Breeden from 1999 through 1992. And we know that Chairman Breeden never felt strongly about anything. We both worked very closely with him and knew him very well. Talk to me about the challenge coming in as the GC, and your client is the commission, your boss is the chairman, and you've got to balance how you frame that advice and keep everybody happy and serve the client. But as I said, Richard had very, very definite, strong views about quite a few things. And I think that was a balancing act that you managed quite well.
Diplomacy. And Dan had left. Dan and Ralph had built a very strong staff. Great people like Tom Riesenberg and Richard Hughes. It was a deep bench in the office of General Counsel. The senior staff was almost legendary. You had the great Linda Quinn, Richard Ketchum, Kathy McGrath, and then Marianne Smythe. These were people that whose names were household names among the best legal circles. So you could learn a lot, and Richard knew he could learn a lot. And Richard brought tremendous energy to the commission, but he also brought a great potential for recruiting opinion, listening to everybody. There would be meetings late at night in the chairman's office, which brought people from all the divisions in, and everybody had a say, and then Richard would assimilate that. It became clear when he went to Congress that he had extraordinary abilities to deal with the Congress. His White House connections were strong. He'd been the advisor to the sitting president. He knew about regulatory and financial agencies because he knew something about the Treasury and the Fed, and he had worked with people on the Hill. So he could take this information and he could use it. He could rise above the level of just the bare facts, what he was getting. And that made him, I think, an outstanding chairman. It led to major achievements like the Remedies Act, 1992, and other things that we were able to do.
So in addition to the division directors and heads that you and I both worked with that were so essential to Richard's success, you had Paul Johnson, Jake Stillman. These were people. Jake Stillman was like an early version of AI. You could ask Jake Stillman any question about anything, and he could recite it in a fashion that was just remarkable. But
Provided only that the question had arisen in a court of appeals case. And if you had a question about 14A7 and he'd never litigated it, he was less sure of himself.
And
why would anyone ask anything about 14A7?
I was going to say he had a stack of papers, probably from the floor halfway to the ceiling, but never failed that if you had a question, he would go 2/3 of the way down, pull out a brief and, give you the answer from a brief that the commission had filed.
So
Johnson.
The Remedies Act. You were general counsel, 1990. Congress passes the Remedies Act. First time the SEC suddenly gets penalty authority over all violations, all respondents, administrative, and federal court or whatever. Talk about that and the agencies.
There were very strong views about the Remedies Act because primarily cease and desist. I think there were voices on the commission and around town that thought that if we got the Remedies Act, if we got the power of the cease and desist and finding authority, that somehow democracy was over. People said it means that McLucas can come and take your money. This was to quote one naysayer. Well, that was not true. It turned out we got the Remedies Act. The cease and desist became something that the bar came to realize they needed that it was a way of avoiding injunctive actions. You could settle cases. It made it possible to do things you couldn't do before. There was one case that came up that was very difficult because it involved attorney liability. And that's the other issue that was coming on while we were going through all of this, was the rise of concern about attorney responsibility and liability. And that, of course, was the proceeding against John Gutfeld and Solomon Brothers and their attempt to monopolize the TiVo market, and the role of the general counsel of Solomon Brothers in that case became a hot button. And that required diplomacy and, I must say, close collaboration and work between the Division of Enforcement, recently headed by one William McLucas. Richard elevated Bill to that job, and it was a good working relationship. And the general counsel's office worked with enforcement on it, and we came up with a solution. And instead of proceeding against Gutfred's general counsel, they came up with a 21A report that said we deem it an appropriate time to amplify our views about the responsibilities of counsel, and where the counsel has the ability to influence action. That's a duty there was a newly created duty of the counsel or corporate counsel, and that was to take action, not merely to sit by, render advice, and watch consequences follow that were harmful. And I think that changed the law, and it changed the view of the Breeden Commission, and it has a long tail. It goes on follows down the table.
And you're right. I mean, the Feuerstein K21A report, which Jim's referring to,
Which always gets called a case.
We don't mention Feuerstein. We did not mention Feuerstein. That was one of the name was not.
well, unless you were living on the planet Mars, though, you knew who it was.
Yes.
And the
Yes.
bar, notwithstanding the fact that it wasn't a proceeding, I think mellowed a little, but not a lot, because the whole notion,
Yeah.
and we're going to get into this in a bit. I'd like to talk to have Si's thoughts. The whole notion of the SEC going after lawyers, much less going after them the ministry.
And a counseling role.
Yes, has been
Yeah.
an enormously challenging issue for the agency over the years. And in, I would say, the vast majority of cases, the SEC totally blew it, because the culmination of those cases, the George Kern case, the Brown Wood decision after the failure of National Telephone in the 1970s, was against the whole law firm for failing to ensure adequate disclosure that their client was slowly sliding into bankruptcy. It just left an unsatisfactory feeling on both sides of the table, I think, but largely in the private sector, that somehow these young lawyers at the SEC who don't know a damn thing because they've never been in the real world want to be out there telling the bar what to do.
It was a strong wind blowing in from the field. I think that the commission was, and Richard was saved. Richard saved the party and he saved the agency a lot of trouble because of his strength on the Hill and because of his ability to explain on the Hill what we were doing. The Hill itself was needing a reason to say that it had done something in the wake of the S&L crisis and the roll-ups that were occurring.
And the backdrop for all this was because Richard had been the head of the vice president's task force on financial institutions. So
Yes.
the S&L debacle of the 80s was really the backdrop for this. Yeah.
And he exhibited poise and confidence when it was needed at the commission. And then you see that again. It recurs again in times of stress when David and Mary Shapiro had to deal with similar problems. I mean, there have been times when I think the commission's fate has hung in the balance, and a general counsel's office and an adept, aware chairman can avert disaster. And that's happened.
Let me turn for a minute, Jim, to internationalization, because when you were the general counsel, you, the chairman, Michael Mann and Linda Quinn spent a lot of time on the globalization of the markets and visiting international regulators and foreign market leaders. Talk a little bit about what the general counsel's role was and what the agency was doing in that period and trying to address the challenges that were emerging with respect to the globalization of the markets.
We were dealing in some cases with agencies such as the CSRC in China that were newly created, and they had no legal structure to look back on. They had nothing by way of documents, nothing to read or to ask questions of. So Richard took Linda Quinn, the one Linda Quinn, Michael and myself, Barbara Thompson, and we met with them in China. And then Richard held an international institute here. They came from around the world and places like Poland, where there had been no free markets, began to get support from the General Counsel's office. One Robert Strahota spent substantially the rest of his career, very talented senior staffer, going into markets, going into countries that were now reforming, taking materials, sitting down with regulators, educating them what you did and what you didn't do to create a market economy. Linda, of course, had the insight about the cross-border offering, the need for a cross-border offering regime that would bring capital into the United States and encourage registration here. And that was a simultaneous project worked out. Our best instincts are sometimes difficult to live with long term. We've had our problems with Chinese securities, with a lot of other issues. The PCAOB is inspecting in China. It may well be that in the long run, it will be seen as having been wise to open the market.
So let me turn here for a minute because we touched on lawyers, the Feuerstein report, and you again came into the role from private practice, and the whole notion of an administrative agency policing the bar and going after lawyers is one that I think everybody in the bar had been sensitive of. What was your perspective? I mean, I know it's something that you were focused on as the new general counsel, and this notion that we have this agency with a bunch of young lawyers going out and policing the bar.
It was a problem that I'd worked with for quite a while. Pardon me. And in fact, one of the earlier cases in 1981, you mentioned Brown, Wood, Carter, and Johnson. And the Carter and Johnson case, while I was in private practice in Los Angeles, I'd written for the Los Angeles County Bar an amicus brief for the SEC. It was an issue that I'd paid close attention to. And there was a chain of factors. Shortly after the Carter and Johnson case, Ed Green, who was another general counsel at the time, gave a speech to the New York County Lawyers Association, advocating the position that you needed to be very careful when you started to bring actions against lawyers, because the commission relies on lawyers interacting fairly with the commission itself. And Ed's speech was quite good, but wasn't seen as perhaps as persuasive as it might have been when the Feuerstein case came along, for example. And I was familiar with all of that because prior to coming to the commission, I'd been sitting in Don Feuerstein's office when he left Solomon. Pardon me. So I was concerned with all of that. And just to bring things back to this firm, I had hired, when I came in as general counsel, a lawyer from what was then Wilmer Cutler, Hardy Colcott, at the recommendation of Art Matthews, which is a recommendation that anybody would pay a lot of attention to. And Hardy and I, because of that background, and because a couple of cases that your people at the time, Bill, were investigating, decided if we could, that we wanted to try to put a nail in the coffin, if you will. And Hardy and I wrote an article that was fairly influential, I think, in the Business Lawyer about circumstances under which the commission should not bring a case against a lawyer. And the phrase that gets used is a lawyer acting as a lawyer. If a lawyer is guilty of insider trading, throw the book at him. If a lawyer is giving a legal opinion that isn't in conspiracy to avoid the securities laws, don't throw the book at her. I mean, there's that kind of distinction, although that's an amorphous concept, but we haven't seen cases against lawyers of that nature since then. What we did see in 2003 with Sarbanes-Oxley was the adoption of the SEC rules on attorney conduct. And the last I checked, the attorney conduct rules generated a lot of interest and excitement in 2003, and law firms set up committees to deal with those situations where lawyers in the firm might see improprieties of clients. Last I looked, since 2003, the number of cases the SEC had brought invoking the attorney conduct rules was zero. Now, I wonder, these things tend to come in waves, and I suspect a lot of those law firm committees have been dulled into quiescence, and I wouldn't be surprised terribly if a case came along in the next 5 to 10 years on the attorney conduct rules, but that was well past my time.
So, one of the related issues to this issue of the SG policing lawyers is the whole concept of administrative proceedings and the authority that exists in an agency that employs the judges and the enforcement staff to charge violations, bring them before the in-house judge, appeal to the same people that authorized the proceeding in the first place. And it's an issue, certainly it's got a lot of currency in the environment we're in today, but you were focused on that in the 90s. You had set up a task force on administrative proceedings. Talk about that and what were you doing? What were you thinking or looking at the time?
Well, when I came in as general counsel, I had a daughter. I still have the daughter, who was then in 5th or 6th grade taking a civics course. And I explained that I was going to be the general counsel of the SEC. And she said, "Well, is that executive, judicial, or legislative, Dad?" And I said, "Yes." And that question has haunted me while I was general counsel and still today. And the ground is shifting under our feet as we speak. If we had today's Supreme Court in 1934, I'm not sure we would have had the authority that the SEC thinks it has today. And the SEC isn't so sure what authority it has. And we'll see how that develops. I think the SEC could live without administrative law judges. I don't think it would be that dramatic a change. Other agencies, not so easily. And we'll see how that evolves. But back to when I was there, I was worried about it, but the law was pretty well settled that this is the way it was, and it wasn't going to go away. And if I had enough trouble, Bill, talking to you about the Private Securities Litigation Reform Act, which was child's play compared to what's going on with administrative procedures.
You know, you're absolutely right in a sense. You know, when you're...
I'm right in complete sense.
You're not over here. When you want and you're aggressive and you're in it, and a concept comes up that you think is alien. How can anyone think we're not fair? 30 years later, when you walk a little slower and your hair is a lot grayer, you look back.
What hair you have?
You know, those were more than fair questions. And I think what you hear from these folks, they were literally the brain trust of the commission, and at least had fortitude to ask some of the hard questions. And when you're down in the trenches in enforcement, you sometimes don't have either the fortitude or the wisdom perhaps to listen as much. let's talk about litigation reform, because that was, if I had to look back at your tenure, among the more dramatic developments in the law and things that the agency was involved in. Tell us about that process and the general counsel's role there.
That all developed out of the chairman, Arthur Levitt, was giving a speech in San Diego at the San Diego Securities Law Institute. And we were brainstorming what he should talk about, and the subject of the proper role of plaintiff's litigation came up. And Arthur caught on to it. And so we drafted a speech for him, and he gave the speech in San Diego. And that developed. And all of a sudden, we were talking about legislation. It was a Republican Congress. And Al D'Amato was chairman of Senate Banking, and he took an interest in the topic. And the ball started rolling, and he had counsel to the Senate Banking Committee, Bob Jufrud, now one of the managing partners of Sullivan and Cromwell, who had started out in securities litigation at Sullivan and Cromwell before he'd gone to Al D'Amato's staff at Senate Banking. And the ball got rolling before you and Linda were really aware that it had gotten rolling very much.
We had the feeling that there was something going on, but no one would talk to us.
And then we had a few discussions within the staff about the proper role of the SEC. And what came out of it all was the Private Securities Litigation Reform Act, vetoed by President Clinton, but then the Congress overrode the veto and it came into existence. And I think it's been marginally successful over the years. What happens from here forward is not my job.
The earlier versions, my recollection is that some of the concern from Linda Quinn and from enforcement was that a motion to dismiss would succeed unless you had a video or a photo op of the defendant removing the money from the safe. The standards basically, we thought, were just a measure that could never be attained. And in some respects, that pushback, I think, helped end up with a statute that was at least workable to some degree.
To some degree, it's right. And we still have arguments before the Supreme Court virtually every year on class certification, all of which come out of that background. And those classes would have been certified easily, I think, 20 years earlier, probably more than 20 now.
Yeah.
But it's been reasonably workable, I would say.
So one final question for you, Si. Talk briefly about the commission's amicus program. I think Central Bank was on the table while you were the general counsel for the issue of aiding and abetting in private rights.
I can't resist raising Stanley Sporkin again, because you raised him earlier. When Central Bank was decided by the SEC, which as you all will recall, said there was no private cause of action for aiding and abetting, Supreme Court came down with the decision on the morning, whatever day it was. And about 1:00 in the afternoon, my phone rang, and Stan Sporkin, then a district court judge in the District of Columbia, was on the phone. He said, "Si, what are we going to do about this decision?" I said, "We're going to follow it, Your Honor." But it raised questions about the amicus process. And I think General Counsel's office has always been an active and important part of the amicus brief, sometimes on invitations from the court, but listened to by the court, because I think the General Counsel's office has always been pretty careful about what it puts in an amicus brief and takes stands that it and the commission are willing to stand behind.
Okay. So
I can't resist commenting on your anecdote. Reportedly, I didn't hear it personally, when Hockfelder was decided, Stanley said, If they want cyanide, we'll give them cyanide.
When you have a general counsel's panel, the enforcement division really takes it on the ear, you know.
Properly so.
So Dick, you were succeeded Cy as the general counsel under Arthur Levitt, and prior to that, you had been the head of the New York Regional Office of the SEC. After Cy left, you came to Washington, became the general counsel, and after several, just as an aside, after several years in that position, harassing me, I left and you took my job. Dick's the only person that ever held those three positions: head of the New York office, general counsel, and director of enforcement. Tell me how the experience, having run New York, really overseeing the exam program, the enforcement program, colored your perspective as the general counsel when you took over and came to Washington.
I think the regional office experience is a lot more narrow than being in Washington at the commission headquarters. As you pointed out, regional offices do two things. They do enforcement and they do exams. There was a small issues division in New York that looked at, filings by small issuers, but it really didn't completely prepare you for what it was like to land in Washington at the commission headquarters, particularly as general counsel, given the complexity of the role. You've heard Dan and others talk about how many functions the general counsel's office performs. And you can't be a little knowledgeable about a lot because the issues that come up are detailed, deep issues. So knowing a little bit about a lot of things doesn't get you very far in that role. But the good news is there were so many long-serving, terrific people in that office. The names Paul Gonson, Jake Stillman are just two, but there were so many others that had years of experience and were very generous in terms of sharing it with you and helping you, through some of these situations that you had to face.
So, insider trading has always been a problem, remains a problem today, it remains a key part of the program. There's no legislative definition. And one of the issues that was in front of the commission and the courts while you were the general counsel was the misappropriation theory and the O'Hagan case. And O'Hagan was a partner at a law firm that represented the bidder for a target company, traded equities and options, got investigated, got sued by the SEC and criminally indicted. That case went to the Supreme Court with the misappropriation theory being the core issue. Talk about the approach to the amicus brief and the worry that case raised about the whole notion of the insider trading program.
Well, if you take a step or two back, I think Phil Parker, who was an associate general counsel for years and years and years, always used to say that the law of insider trading is defined by the cases the commission has lost in the Supreme Court. And so there was Chiarella, there was Dirks. The commission had kind of a bad streak in the Supreme Court, and mostly at the hands of Justice Powell. And even though in Chiarella, though the issue of the misappropriation theory hadn't been raised in the lower court, so it was sort of swatted aside by the Supreme Court, but nevertheless, 5 justices in concurring or dissenting opinions talked about it and thought, this has some traction. This sounds sensible, but we're not going to consider it because it wasn't raised below. Powell was pretty clear that he was not a fan of a misappropriation theory. Powell was not a fan of the fact that there had never been legislation involving insider trading, that the SEC had never used its rulemaking to define insider trading. So he was basically very much and openly against kind of crawling out on the limb and trying to expand insider trading into new areas. So the misappropriation theory was such a vital tool for enforcement and for the commission. The classical theory, of course, only covered company insiders, but anyone else who committed a fraud and traded on information improperly obtained if you didn't have the misappropriation theory, you were out of luck. So when the criminal conviction went up to the Supreme Court, of course, that wasn't our case, but we were very much involved. The U.S. attorney out in Minnesota couldn't have been more gracious to invite us to be an integral part of the process. And interestingly enough, Paul Gonson, who was very, very involved and sat at counsel table during the argument, he had also sat at counsel table at the Chiarella case, which was 17 years earlier. So that's sort of the continuity of the experience that you had. And Paul and Jake, and we were blessed to have Michael Dreeben from the Solicitor General's office, who even then everyone looked at as a star, and his star only rose over the years. But he was just a wonderful, asset from the Solicitor General's office. And if you look at the O'Hagan opinion, actually, Justice Ginsburg all came out for the commission's benefit. I guess we should jump forward and say, of course, the misappropriation theory was upheld 6-3. But Justice Ginsburg not only quoted from the briefs, but she actually quoted what Dreeben had said during oral argument, which was highly unusual. He had basically given up the hypothetical, well, what if somebody steals a lawyer's briefcase that has confidential information and they trade on it? He said, not insider trading, no deception. It may be some other crime of stealing, but the essence of insider trading is there has to be a fraud and deceit upon the source of the information in the misappropriation case. So he did a brilliant job, and it was very exciting for us. Although we had our bets hedged, we had our bets hedged, and we pulled out from the commission's vaults, if you will, the one and only other time that the commission had sort of advocated a legislative definition of insider trading, which was back in, I think, 1987, after one of the cases, Chairman Regal from one of the Securities Senate subcommittee, Securities Subcommittee of Senate Banking, had created a committee chaired by Harvey Pitt after he had left the commission to come up with the definition. And the commission had sent up its own definition of insider trading at that time, which didn't align with Harvey's group. And Regal sent it back and said, I want you to see if you can harmonize this. And wasn't completely harmonized, but at least the SEC had a draft of a definition and legislation on insider trading that it could look to in the event that, we lost the case. So we pulled that out quickly and looked to see what it said about misappropriation theory, and we were sort of ready to go. But the good news was we won the case, so we didn't need to do that. And maybe future commissions have proposed definitions. I'm not aware if they have. Certainly when Preet was doing a task force to come up with legislative fixes, I assume there was some consultation with the commission at that time. I don't know what it was, and I assume that what the Hill was doing at that time. There is a bill that's passed the House involving insider trading. I assume the commission has been brought into that discussion. I hope they've been brought into that discussion, but I don't know for sure.
So, in addition to insider trading, you were the director or the general counsel under Arthur Levitt. What else? I mean, he was somebody who was all over the lot on addressing what he saw as problems through speeches and pronouncements. And he gave the number speech. He talked about municipal securities. There were enormous initiatives in that area that had been relatively dormant for 20 years because under the Sporkin program years ago, there'd been the case against New York City. Talk about those initiatives and Arthur's approach to bully pulpit and then directing the enforcement resources.
So it was something, I think, a bit unusual that SEC chairman was as outspoken and talked about some of these issues publicly the way that he did. And I think part of it was attributable to his background. He came from the industry. He was knowledgeable about the industry. I think none of us on the staff had pretty much ever heard about municipal securities or realized that there was a pay-to-play problem and things of that sort. But he knew about this from his own experience. And he highlighted these problems and drove through solutions. I think the pay to play was the first of them. And then he got quite interested in auditors and accountants. I think at that time, there were some fairly startling statistics that the chief accountant, who was Mike Sutton, brought to his attention about at large accounting firms, the gravitation of the business from auditing function, consulting, and the amount of fees that were generated from consulting as opposed to the audit function. And I think he was very, very worried that the audit function was becoming a loss leader and was subject to compromise because people were so anxious for lucrative consulting business. So in probably his biggest battle over the years, he kind of took on the accounting profession, and it was not easy. I think he thought that, we'll sit down, we'll talk to them, we'll get them to see the light and to do the right thing. And it didn't really go that way. They pretty much said pound sand, and he didn't like that so much. But the enforcement division, I think, saw a lot of the things that he was talking about in cases and investigations. And the problem with his approach was, we really didn't know until these speeches were being drafted what the issue du jour was, what was going on. And so we'd kind of go, people are going to expect us to be bringing cases showing that these are issues. And as you know, that was a challenge to get the cases to catch up to the issues that he was identifying. But certainly with the independence issues, we did see some things in some of the enforcement investigations that were pretty eyebrow raising in terms of the way some of the firms had, really in pursuit of the consulting business had put aside some of the audit functions or compromised that. And certainly with respect to his numbers game speech, where he talked about a lot of the kind of accounting gimmickry, cookie jar reserves that companies would take a reserve when they could afford to, and then bleed it out into income, when the quarter wasn't so good. We did bring cases on those after the fact, and we were able to substantiate that what he was saying really had some validity, but it was always a kind of a hurry up and catch up because the chairman has identified these problems and not everybody sees these problems. They haven't been, the subject of enforcement cases, but most of the time they were the subject of enforcement investigations that just needed to be expedited a little bit.
So let me ask one final question of everybody in the panel. The whole notion that more than two commissioners could never be in a room and talk about anything without convening a meeting and complying with the Sunshine Act, I thought 30 years ago was nuts, and I still think it's wacky. What's the predicate for that? And is it at the commission, were we overly sensitive to that idea that you can't get three people in a room to talk about a problem, a case, a matter? Dan?
Well, I mean, having lived through both eras, and of course, as I think everybody knows, the predicate is the government and the sunshine.
But that's just a law.
Or we did try to follow.
Problem of enforcement.
But I think it was not a positive development in terms of
When
collegiality and decision making.
When I was there, we got down to two commissioners at one point, as you remember, Bill.
Yeah.
It was Steve Wallman and Arthur Levitt, and we had people in the lobby making sure they didn't get in the elevator together because you couldn't have a majority of the commission, and we had adopted a quorum rule that said two commissioners is a quorum, subsequently challenged and upheld by the DC Circuit. But we were worried about that problem, adopted it before we were down to two. And the Governance Sunshine Act says the commission as a commission has to act in public. And you can't, if they start talking in an elevator, God knows what they're going to say, especially with Arthur.
Arthur, was not a lawyer, so he didn't always appreciate some of these sort of technical requirements, and he would, charge down the hall to head to a commissioner's office, and you'd sort of have to go, whoa, hold on here. And he didn't like being told that he couldn't go and talk to one of the commissioners. It didn't seem to make sense to him. I should also point out
It doesn't make sense.
yeah, I would agree with him on that. But as Dan said, government and sunshine law is the law. Arthur also would play golf, and he liked to play golf with Dan Tully, who was then the chair of Merrill Lynch. And I remember saying, no, the optics are so bad. There's just so many things that can go wrong with this. And I remember finding a cartoon in a newspaper once about, what happens when you play golf. And I sort of delicately said, we talk about this, but this is where you're going to end up, if you do that. So we decided that we would send Phil Parker, who was a golfer, on these golf outings. And we said, now, Phil, if Arthur hits the ball over in the woods, you hit the ball over in the woods. Do not leave his side.
Arthur's great satisfaction was in regularly beating Alan Greenspan golf. And the first time I went to Europe, people asked the late Dick Phillips why the commission functioned with 3 and 2 being a requirement. They could not fathom the fact that you could have a collegial commission that got business done if they weren't all the same political party.
We're prescient about where we are now. That's correct. So with that, we're going to take 5 minutes, only 5, please, and we're going to turn to the next panel. This has been great. I mean, you can tell why Infant's really been able to do what it's done, because we're doing words you could get as General Counsels.
Okay. Thank you. That was great, by the way. That's why I could never have gotten hired in the General Counsel's office. These guys were just, I was poisoned after being in the division for about 6 months. We're going to now turn to the more recent General Counsels and start with David Becker, who was the General Counsel under Harvey Pitt from January of 2000 through May of 2002, and then returned as General Counsel under Chair Mary Shapiro from 2009 to 2011. Now, David, you have the distinction of being the only General Counsel who either re-upped or was conscripted for a second round with the SEC. And after in your first experience, you were there, you came in just before 9/11. And it had to have been a remarkable period for the commission. The markets were in disarray. There was an enormous amount of concern about whether we could even have a technologically functioning system after 9/11. Talk about your role and the hearing from the commission of what went on in the aftermath and how you were able to work with Harvey and make sure that the markets remained open and stabilized as much as possible.
Okay. Before I do, I just want to mention for the older people here, particularly the younger ones, Bill mentioned the cease and desist authority earlier. And that cease and desist authority exists because of a law review article written by a Wilmer partner, Arthur Matthews. And he was an extraordinary man and one of the greatest practitioners in the securities business. Just as a tiny anecdote, when I was at the commission first, or I was deputy general counsel, I think, the commission had a administrative proceeding the first time. It used its speech and desist authority, and I either wrote the opinion or edited of the commission. I don't remember, but I added a footnote saying to the opinion, saying just what I just told you about Art's role in
creating this authority. And it was shortly after he died. And so I thought that would be an appropriate thing to do. And unfortunately, one of the 4 commissioners just crossed it out without explanation. So that's a way of avoiding Bill's question. Now, did you say something about, okay, 911.
I forgot.
Yeah, I know. That's my motto these days. On 911, I was in my office and there was a TV that was often on just to keep up with the news. And someone came running in and said, a plane has crashed in the World Trade Center. And I ran into Harvey's office and I spent the rest of the day with him. What Harvey was a complicated man, and in many ways a wonderful man. But when something important was going on, he had to be in the center of it. When it came to 911 and all the dreadful things that happened, the first thing that Harvey did was convene a meeting with the heads of various Wall Street firms in New York City the day after 9/11. I was there with them, and Harvey, before that meeting and thereafter, he spoke to people in Division of Market Regulation, trading markets. I can't keep them straight. They keep changing them. And he made clear that our approach was going to be, what can we do for you? How can we help you step back from this and recover from this? And that was the theme that the commission staff took thereafter. And what Harvey did was, first of all, get good information mostly from heads of the various firms. It's a very interesting meeting in New York in which certain of the firms were bragging, oh, we got this, we'll do this right away. And then the head of another firm said, well, let me explain. We have this electricity station down here, and that can be completely out if X happens or Y happens. It became clear that there were a lot of firms where it was pure bravado, and other firms who are not trying to show off about how great they were, who confronted the problems without sugarcoating them. And Harvey worked with Dick Grasso and put himself, in one sense, out of the picture, gave the canvas every division and said, what can you do that would be helpful? Ran some ideas in front of them, like stock buybacks to a degree that might otherwise not be permissible, but in order to promote confidence in the markets. So, and we had at in the General Counsel's office, we had various levels of expertise, and we worked with and specialists, and we worked with the various divisions. Some of them already had emergency plans, and basically that's what we did.
during your tenure, David, this was a period of time when the state attorney generals jumped into areas of enforcement and investigation that had always been viewed as exclusive prerogative of the SEC. And the prime example of that was Elliot Spitzer.
Oh, Elliot Spitzer.
And that raised a host of issues, not the least of which was when you cooperate with other regulators and lawyers and agencies, usually there's a good faith basis that whatever you say will be confidential. Well, when you were dealing with some of the state regulators, you'd be better off taking out an ad in the New York Times, but it would be late because the things you said to your co-regulator would be leaked before it could get printed. Talk about the challenge the commission faced. And this is something that enforcement was navigating, I think, but it's something that as the general counsel and the commission, you had to be trying to wrestle with how are we going to deal with this and how are we going to deal with it in a rational way?
Well, yeah, you left out one of the implicit understanding. That is, whenever another regulator, however they characterize or report what it is your conversation are with them, they were true and not lies. So
This is great to have somebody on the panel who's less diplomatic than me because telling it like it is. So
stick around. So I got a call from the head of the general counsel of, I think it was Maryland, one day in a panic saying, New York State's going to go public with complaints about us and claiming all sorts of violations. The use of analysts, it's not true. And is there anything you can do to prevent this? To which the answer was a very nice no. That's not the business we were in. But we were sensitive to the fact that we have a national market system, and we don't want some in individual state setting as settled law certain things that participants in the markets had to do or could not do. And so Harvey sent me and Annette Nazareth, head of the Division of Trading and Markets, up to New York to talk to Spitzer. And we had a very friendly conversation with him. And we said, look, you're going after fraud. With our blessing, we're all for it. Any way we can be helpful to you, we'd be delighted to do it. We said, you ought to talk to Steve Cutler, then head of Division of Enforcement, and you're going to like him. You're going to find him aggressive, and we want to work together. The only thing that we care about is when you come upon remedies, prescriptions about how the way they do business needs to change with structural. There's some talk about walling off analysts from salespeople. Anyway, we want to do that together. We have expertise, and we think it's important, again, that there be a coherent national market system. Fine, that's fine. That's great. So Annette and I took a plane home. On the plane, we learned that Spitzer has given a press conference and said The SEC tried to stop me from doing what I needed to do. But I care about the public and all that phony crap. That's how, and so how do we handle it? Became very clear who we were dealing with. So we were sort of protective, but we did care what we were doing, about what he was doing. And it became clear to him, I think, that he didn't have all the expertise that he should have. Basically, we worked reasonably well with him, and we learned a lot about what he was like, and last, what the New York Attorney General was like when it came to securities matters. And there are other stories, which I won't take the time about, other enforcers in New York and the things that they did.
So David, during your second stint, there was another market mess, the 2008, the market collapse, and two questions, I suppose. Number one, what was the view from the General Counsel's office and how you help the commission navigate that? Number one. Number two, Dodd-Frank passed in 2000 or after the 2008 market collapse. And I'd like some of your thoughts about how that legislation came together with the commission's recommendations and your guidance and the agency's input to the actual legislation.
Well, life changed dramatically in the few years I was away from the commission, because we did have this recession. We have, I mean, as important as we think that the Securities and Exchange Commission is, relatively speaking, it's a tiny agency in a big federal government. There were times, certainly during my first tenure, and when Arthur was certainly when Arthur was chairman, where he would have loved to have been visible to the White House, to have the White House care at all about anything that he was doing. We talked about order and independence. He couldn't get them interested in them. And but right before it came back, when Senator McCain was running against then Senator Obama for the presidency, one of the things that McCain was going to do is grow out the existing chairman of the Securities and Exchange Commission. Who knew anything about this? Who was at the Securities and Exchange Commission? As I said, people there would die to come to people attention, but the world had changed. And one of the first rules of Congress is that if bad things happen, quickly figure out who to blame, and then get second step, be outraged that other people aren't as outraged as you are. And so we had that. We had the Stanford case where the commission the enforcement did not show itself well. And then, of course, we had the Madoff case, which was a real, it was a punch in the gut, as various people said. So that's by way of background. We were, at that time, the commission was in an institutional position of extreme weakness. And so these Dodd-Frank, for example, was was a bit of a catfight with us and the banking regulators. Now, one of the things that I learned in my first stint with the commission is that whatever you hear about infighting, power grab among agencies, between agencies, nothing you have heard is as bad as the ill will between the banking regulators and the SEC. The banking, God's honest truth, and the banking regulators thought, we just didn't understand banking, and all we wanted to do is bring cases because that's the way we saw the world, and we screwed things up in the banking community as a result. We, having the greater wisdom, thought of the banking regulators as a bunch of weenies. And so
I think you belonged in a division of enforcement. I got to tell you,
yeah, I thought so too, but the standards we took. So the whole Dodd-Frank thing was a series of like thrust and counter thrust between us and the banking regulators, who had the principal role in producing like Dodd-Frank. We were told by one of the people in Treasury, I think he may be ex-Wilmer, nice guy, smart guy, that we basically represented an extreme wing of the Democratic Party. So that's what we did. We fought and got the best that we could.
So one of the things that David said, which really resonates with me, is he mentioned the Stanford case and then the Madoff miss. And, it really is quite true. When you're in that agency, every night when you leave, you are wondering, did somebody somewhere do something horrifically stupid or miss something that is going to come back to haunt all of us? Because the possibilities are enormous and the consequences are devastating. And I think when you're in the general counsel's chair or the enforcement division, it's something that you can't avoid. It's the price of public service, but it never goes away, and it's a worry you always have. Let me turn to Bob. Bob, you were the general counsel under Jay Clayton, and all chairs of the SEC face what I would say are enormous political issues, whether from the right, the left, the staff, the Congress. It's a really challenging job. Most of them have been extraordinary, whether you look at Mary Jo White or Arthur or Richard or Bill Donaldson or Mary. But that said, Jay Clayton to me was the master. I mean, I think he navigated his tenure at a time in Washington when things were so polarized and so challenging that was quite remarkable, because kept his focus and seemed to steer the agency really well, remarkably well throughout his tenure. Talk to me about the general counsel's office's role in keeping the focus and keeping the message and keeping, to the extent you could, the agency out of getting sidetracked into some of the craziness that can happen in this town.
Just thank you. Briefly, thank you all for being here. And I especially want to thank the current members of the GC's office who are here in the SEC area, including the current general counsel, right? Bryant, I see you over there, runs all the rules in the office now. I thought I saw Donnie earlier. The head of IM is here, Brian, and I know how busy they are. And thank you for being here. And thank you for the litigation enforcement people supporting us, like Tony, I see, and Joe, right? And no history of the FCC's General Counsel office would be complete without talking about Michael Connolly or Richard Hume. So thank you, both of you, for all you've done. Great to see you here. Richard, you still look younger than anybody else in the room. It's amazing. Yeah, Jay would be, I mean, it's like a general counsel's dream to work with him, right? He and I are best friends, which that doesn't hurt either. But just I have so much respect and trust for him. He's a lawyer, right? And so he's willing to take counsel. I think the general counsel's office ebbs and flows in importance sometimes in commissions, depending on who the chair is. He happened to care about us quite a bit, right? And Jay wasn't one who cared about what party you were from, right? He just wanted people who wanted to do a good job and do a good job for the American public. So it didn't matter which lever you were pulling in the voting booth. He just cared about the office of the general counsel. He took our advice. He didn't always agree with it, but he'd always listen. He wanted to know the risk, then he'd make a decision. I think that's what a good leader does. He was easy to work with.
So when I was at the agency, I had the benefit largely of having general counsels who we could disagree or agree or argue, but you could work with them because the relationship with the office and with the chairman's office was excellent. And I'm assuming that you work to develop that same relationship with each of the division directors and office heads, because your role with this chairman, I don't think anything was going anywhere if it didn't go through the general counsel's office.
Yeah, so Jay was given advice of not acting, he was the chairman until he was the chairman. So I interviewed a lot of them and helped Jay hire them. So yes, they did listen to me. And we had
I had to work to get that. I mean,
and we had a great relationship. We still do. I still annually host a weekend at the Jersey Shore for the whole team. And so it's really, we have a special relationship still. Some of them are getting together today at the Met Club. So it's been, it was a great group to work with, and we still are very close.
So let me talk about some substantive issues. What from the defense bar's perspective, the SEC's application of its penalty authority has been both a source of grousing and, in some respects, a complete mystery. Under the Clayton Commission, how did the General Counsel's office work with enforcement and the chairman of the commission to come to some more rational way of using that power so that there might be a better either understanding or acceptance of the use of the authority by the defense bar and the industry and the or rogues that got dragged into the enforcement net?
Well, I think earlier in the earlier panel, we were talking about defending your dissertation, which I think is always healthy to do. And Commissioner Peirce would make you defend your dissertation. If you came up there in enforcement, you can ask Joe Brunner about this under cocktails later. You needed to know what you were talking about. You better have some history, some precedent. And she was going to make you defend your dissertation. So there was going to be tethered to something. It wasn't going to be a number you were going to make up. There was precedent was going to be important. And so I think that was very healthy, and always is healthy for enforcement to have someone there. It shouldn't be a rubber stamp, I don't think, at the meetings. I mean, actually go there and explain your case and get asked some hard questions. I think it's a really good process.
There was a mention earlier, I think by Dan, that maybe before the Sunshine Act, the agency acted as frequently as possible as a body. There was unanimity. And that wasn't always the case, but under Chairman Breeden and I think Chairman Levitt, there was an enormous emphasis on accommodating views and then speaking with one voice. I think there's a view that it serves the public interest and the credibility and integrity of the institution better. That seems to have eroded a little bit. And I'd like, to the extent you're comfortable, your thoughts on, and I'm going to ask Megan the same question.
on that sort of change in the climate, which is reflective of the rest of the world in Washington, I suppose, today.
Yeah, those days are gone. It's more political, obviously, and there's, I think you do a good chair still walks the halls and talks to people and tries to do it in a friendly, respectful manner, stake out different positions. At the end of the day, some votes are going to be 3-2. It's just how it's going to be, or 4-1, whatever it is. So 3-1, 4-1, 3-2. I guess they're not going to be 4-1 typically, but some are going to be that way. There's still a lot of 5-0 things. Still a lot of things are 5-0, but certain things that would be viewed as politically sensitive are going to be 3-2. That's just how it's going to be. It's not going to change.
Over the last few years, the courts have been not so friendly to the SEC. And talk to me about the SEC's role in dealing with the Lucia decision, where the court decided the ALJs are administrative officers subject to the Appointments Clause, or the Kokesh decision, where the court held the SEC claims for disgorgement operate as a claim for a penalty and therefore subject to the 5-year statute. How did that affect the assessment of enforcement recommendations and authorizations going forward? Was it to have a more sobering or conservative impact on the thinking?
Starting with the ALJ cases, I mean, as was said earlier, we have 2 or 3 ALJs at the SEC. Maybe we had 3 when I was there. You really, except for certain statutory mandated things, you don't really need to run things through them. I think many people in the room would say that putting the insider trading cases in those courts was a mistake. Should not have happened. A lot of risk for the institution when that did happen. It's really, I mean, I actually think they were fair, to be honest, but from the outside, it's not a great look. Right. And so I think that was a mistake. I think the Supreme Court decisions have allowed the other agencies to operate while still getting the SEC in a place they should be, right? When I was brought into the Solicitor General's office and they said, how many ALJs you have? I said, we have 2 or 3. And Social Security said, well, we have 1,600. And Health and Human Services said, we have 100,000 backlog cases. So you need to figure out something that works for everybody. And I think the court actually did a pretty good job of that. So I don't think that was really, I know the people who were the judges and their staff, it wasn't easy for them. But I think it was a good transition. I think it's worked fine, including under Megan was there and under Gary, Chair Gensler. I think it worked well. And as to Kokesh Kokesh, I think Joe's got to answer that one, but I don't think it really was that difficult, right? I mean, I think we were able to still get the enforcement cases where they needed to be. As to the remedies, I think there's enough other remedies that you have in enforcement. I think that it was very workable.
Did the collection of those cases elevate the General Counsel's role in litigation risk assessment and advising the commission on maybe this one's too close to the 6-inch test and we should throw it back?
Well, those were cases that were there when we showed up, you might remember. And Jay, to his credit, didn't run away from them for the institution. He continued them and continued fighting them. And we lost some of them. But I think, it was always, I think we always cared about not taking undue litigation risk. I think if you look at our record on the cases that we weren't left with, I think it's pretty strong. Got a Michael Conley.
So, and I'm going to come back to everybody with a question toward the end. But Megan, you were there from 2021 to 2025 as a General Counsel under Chairman Gensler. There was nothing going on. I'm sure you had a lot of leisure time, right?
Nothing at all. But on that note, if I could just echo Bob's thanks in particular to the many folks from OGC who I see in the room tonight. It's wonderful to see all of you. Thank you for coming. And I know when we first started, we were talking about OGC in the 70s, and there were 20 lawyers, but they were all top-notch, dedicated public servants who were experts in their field. The office is much bigger today, but the same can be said of all the lawyers in OGC today. So thank you all for coming. And also, I wanted to acknowledge Dan Berkovitz, who is my immediate predecessor and somehow escaped the panel. So he is in the audience.
So, Megan, during your tenure, there was an explosion of rulemaking proposals. There were issues around short sellers. There was concerns about market integrity after the GameStop situation. There was a focus on payment for order flow and best execution. How did your office manage its role in overseeing both what the operating divisions were doing, recommending, and what the client was driving for and what the client wanted?
Well, I took the job because I wanted a job that was interesting and would present a lot of difficult legal issues. And I knew that this one would, especially under Chair Gensler, who had a very ambitious regulatory and enforcement agenda. The job did not disappoint. So we did stay very busy. But in terms of how we worked with the operating divisions and enforcement, a lot of that, as all of you know, is about relationships. So relationships with the chair's office, with each of the individual commissioners, relationships that staff have with their counterparts in the divisions around the commission, and really building on those relationships so that the folks who are making the policies are coming to ask us about the legal issues early on in the process and are listening when OGC is flagging concerns, and understands that we're both there to provide the legal guardrails, but also as part of the team. So we always wanted to go into every conversation, and we worked hard at this, trying to understand what the goals were and how we could help get there. And not everything we did was sustainable in the courts. I think we could have an entire session about that. But certainly GC was instrumental in making sure that we had good defenses for the rulemakings, and that we had strong arguments in the enforcement cases, because of course we knew all of those cases were coming to us to defend on appeal. So we wanted to make sure from the beginning that we were on solid footing.
So Megan, Bob alluded to the fact that it's a new day and you see 3-2 votes, or, majority, minority, and 25 or 30 years ago, I would say there was a much more frequent consensus coming out of the agency. There were no less very, very serious philosophical disagreements and debates and arguments about policy and market regulation and disclosure and oversight. But the agency, I think, worked harder to come to a consensus. And those days are gone. How did the General Counsel's office navigate working with individual commissioners and the commission as a body when you have a very strong chairman with very definite views pushing for a certain approach to either disclosure, oversight, or a regulatory initiative?
Well, a few responses. One is just to take a step back and remember that Congress created an agency in the early 30s that would be a bipartisan agency with, no more than 3 members from one party. And the agency has operated differently over time in terms of the interactions among the various commissioners. I think part of the congressional design is to allow for dissenting votes, dissenting voices to be heard. And those play a really important role, even when the commission can't reach unanimity. And we see some of that play out in litigation too. So, as a chair, if you have a dissenting colleague who is going to write a powerful dissent, and we talked about Commissioner Peirce kind of putting you to the test and making you defend your thesis, if you didn't do it, that was going to become clear to everybody in the public because she would write a very compelling dissent. And then we would see that in briefs filed against us in litigation. So the very active dissenting plays an important role in holding the chair and the majority accountable. And I do think that, while we are seeing more dissents and more, 3-2 votes or 3-1 votes, there is also a lot to be said for the discussions that happen behind the scenes, even if you can't get to consensus in shaping the policy choice of the majority. And you asked me too about how GC navigated all that. That's sort of big picture. But again, for me, it was about having the one-on-one meetings with each of the commissioners, remembering you're representing, notwithstanding what any one chair might say, you're not the lawyer for the chair. You're the lawyer for the commission, and having those relationships with all of the commissioners' offices and knowing that they would come to ask me when they had difficult legal questions, that they could get my best legal advice and that they could rely on that legal advice. That was critically important to me in the job. I know it's important to Dan. I watched him do the job before me, so I had a good role model in that.
Yeah, I mean, the point you make is critical, because all the general counsels that I worked with and seen operate had enormous credibility with individual commissioners. They may agree or disagree, but they were not perceived as advocates for the boss. They were perceived as advocates for the commission, and that's critical to maintaining your relationship. Let me ask you two more questions. One is going back to the judicial challenges that the agency was facing. Talk about the Jarkissi decision and the jury implications. How did the General Counsel's Office help craft the agency's response going forward, and how are we going to deal with this as an agency?
Well, so Jarkissi had actually been litigated in many different iterations. And the first time I came to GC, I don't know, Michael, you may not remember this, but I was at the Department of Justice. We were representing, Lucia was my case there. We were representing SEC in the Lucia and related cases, of which there were many. And I came to moot court for Donnie, who was arguing Jarkissi when it was still in the administrative proceeding. This is before Cochran and Axon. The question at issue was, could someone jump out of an administrative proceeding to go to court to challenge the administrative proceeding on constitutional grounds? The answer then was a definitive no. That, of course, the Supreme Court has changed that. But I remember, because the Seventh Amendment came up in this argument, and this must have been 2015. I mean, it was maybe 2016. It was a long time ago. And I was walking in not in the scheme of this panel, but in the scheme of how we
You don't know a long time, trust me. Yeah.
So, Bill, earlier I was thinking, I wonder if I'll be back in 40 years. And
Well, thank you for mentioning that. But yes,
so I was walking back to DOJ with a very senior lawyer from DOJ, and we were having a good chuckle about the fact that someone thought that, the Seventh Amendment might be a viable claim against an administrative proceeding. And then you fast forward, and of course, in Jarkissi, we were working closely with DOJ and the SG's office. We lost on a number of grounds, but even going into the Supreme Court argument, nobody thought that the Seventh Amendment would be the issue the court decided the case on. Everybody thought it was going to be the removal of the SEC ALJs. And it wasn't until we got into argument, and Brian Fletcher was doing a tremendous job, was up at the podium, and we kept thinking where the removal questions and everything was about the right to a jury trial. So it was quite a surprise. It was a surprise not only for the SEC, but for agencies. Bob mentioned all the other agencies that use ALJs. It was a surprise across the government. And obviously, the questions relating to Jarkissi are still being litigated. But GC was instrumental both in the litigation and in helping implement the decision when it came down.
so a final question for each of you. David, I want to start with you. When you arrived at the commission to be the general counsel, the first time, the second time, while you were there, what was the one thing that either struck you the most or surprised you the most, or that you were most pleasantly pleased with when you walked in and saw what was facing you in terms of the staff, the people, the institution, and the commission?
I'm going to give you a truthful answer. I was so thrilled to be at a private practice.
This is why he had so much credibility when he made an argument.
So that's the instant thing. But all these things are all about relationship, and Megan mentioned that. But it's about the most important thing. My first task was to develop a relationship with my clients, particularly the senior clients, and that preoccupied me both times I was there.
Bob? I would say going in, I had people like Liz come up to me and tell me how strongly they felt about the institution and how much they were willing to help. So I could tell it was going to be a really good place to work. And it was a great place to work. The staff are so good. And I come from private practice. They're right on par with that. They care and they work hard. As long as you go there and lead, and they want to be led, and they want to help the Main Street investor and the individual investor and protect them. And it was an honor to work with them. They were great.
Megan?
I think the breadth of the work that the office does was a surprise because I'd seen some of it, but not, there's so much, and we haven't had a chance to talk about it today, but so many different functions that the office plays, especially in the modern era. That and the number of awards that I gave out for more than 30 years of service, which it just speaks to the fact that there's such a depth of institutional knowledge and commitment to the office among the staff.
So, look, this has been an enormous amount of fun. I can't tell you how enjoyable it is to sit here and be on a panel with the folks that have sat up here, and to look at and see all the folks that I know who worked at the SEC, people who are alumni, people who are still there. I think the magic of this agency, even in the current environment we're in, which is challenging for everybody, is that the people that it attracts and the people who do public service the way somebody like Meredith has done, or Eric Schwartz, or Kate Fulton, or Colleen, or there's just a dozen or more people here that I could point out. You basically do it because of what you just heard from three people here. You develop relationships with people whose heart and head are in the right place. And this has been a great hour and a half, 2 hours. Thank everybody for coming, and thanks to the Historical Society for putting it together. And you guys have all been spectacular. Thank you.
I just want to say thank you. Thank you, panelists, for, I just like to, verklempt here. It's just really special to have everyone together to relive those days and to hear such brilliant people speak. So thank you for being here. I want to thank Meredith very deeply from our bottom of our heart, for all her leadership for the SEC Historical Society, for all her generosity. Thank Wilmer for having us here. And Kathleen Graham, our ED, has just done an amazing job pulling this together. For those of you who don't know me, I think I know most everyone, but I'm Liz Gray. I'm president-elect of the SEC Historical Society. I recently retired from practicing law at Willkie. My partner, Bob, there. I was a litigation partner and co-chair of our securities enforcement practice. Like many of you, I have a deep connection with the SEC. I spent 13 years there working for some of you, and working a very memorable time with Chairman Arthur Levitt. His name came up so much today. It was fun to hear that. Our society preserves the history of the SEC through the Virtual Museum of Financial Regulation. Hopefully you all have visited that site. We hope you will.
And we hope you'll also think about donating if you haven't already. There's the QR code. It will show up around the reception. And before we leave, I wanted to reiterate what Megan and Bob said, to thank the current staff and to thank all the former staff as well, many of us in our community. We know how dedicated you all are. We know it's a hard job. We know you work tirelessly and you do make a very significant difference. So thank you. And I hope you'll all join us for the reception.